Hey, this is Angela, and you're listening to Season 2 of Study for the Bar in Your Car, the podcast where you can study for the bar in your car with the help of me, Angela, your host, and also my AI buddies, Claude and Ma. So this season, we are tackling contracts. So contract law has been one of these subjects that I've wrestled with so much. I think people that are good at contract law are actually good at math. And I think if you're like an English major or you're a humanities major, I think contract law is a little bit harder to wrestle with. Anyhow, so you know how this works, or if you're new to this podcast, let me tell you how it works. So I've taken the bar a few times, and just because you've taken the bar a few times, it doesn't mean you've failed it a few times. Now, I failed it a few times, but sometimes you're taking different bars for different states. And for this bar season coming up, I am actually studying for a different bar than I had previously been taking. So I previously taken the Washington, D.C. UBE bar, but now I'm moving on to another jurisdiction. Anyhow, so because I've taken the bar a few times, and also because I went to law school, I've been in law school since 2017, off and on. So I'm a dual American British citizen. I went to law school in the UK, and then I came back to the US and had to go to law school all over again. So I've got like a lot of notes. And because a lot of the law is common law, I've had very similar educations. Now, obviously, things are different from in the UK than they are from here. And I've definitely separated my British notes from the American ones. But I have a lot of American notes. I have a lot of outlines. I have a lot of things that I've done that I need for bar study. I mean, maybe this is even too much, but I've taken all my data. I've put it into AI, and then I had AI generate a podcast. Now, whilst I've been creating this podcast, they've actually changed and updated the AI software. So what you'll find is that some of the later episodes are a little bit better in terms of content than the earlier episodes. But I mean, it's all good. Now, a few reminders. I am a law student, just like you. I am studying for the bar. So I'm not an expert in any of this. But if there are mistakes, and AI does tend to make some mistakes sometimes, I try to correct them. And in fact, I've had to redo some of these podcasts, all over again, because of errors that the AI has made. So, I'm not giving legal advice because I'm not a lawyer. I'm not barred by any state, but I am barred by 2 Native American tribes in their tribal courts. That's a whole different story, and I'll get to that at some point. So take all of this with a grain of salt. This should not be the only way that you're studying for the bar. This really should be a supplement while you're in your car. If you need to occupy your mind, if you want to, study while you have this downtime, or maybe you're on an airplane, listen to these podcasts and listen to the content that Maud and Claude go over. Anyhow, if you need to reach me, I am podcast@studyforthebarinyourcar.com. I'm also a law clerk, so I work with attorneys around the world. So if you are an attorney, or you work for an attorney, or know an attorney that needs an extra set of hands to work remotely, you can email me at hello@legalwriterandlawclerk.com. Anyhow, that's it for me. Take it away, Maud and Claude.
Welcome to this deep dive, custom tailored for you, the learner. You're looking to get a solid handle on complex topics without getting bogged down. And today, we're tackling a foundational area of law that impacts pretty much everything, contract law.
Absolutely. And a big thank you to Angela for suggesting this topic.
Yes, definitely.
Yeah.
Think of this as your personalized study for the bar in your car on Contract Law 101.
It's a subject that, well, it might not sound glamorous, but as you'll see, it's kind of the invisible framework that governs so many of our interactions, from the everyday stuff to, monumental deals.
Totally. Understanding its basic principles is just incredibly empowering.
For sure.
We'll be using Angela's notes as our guide today. It's a really comprehensive overview of the core principles. Now, contract law sometimes gets a bad rap for being dry, maybe?
A little bit, yeah.
But it's honestly full of surprises. It pops up in everything we do, from just agreeing to terms online to these massive business deals. Plus, it's got some really memorable cases attached to it.
Oh, yeah? Like what?
Well, you might have heard of Palsgraf and torts, maybe. But contract law has its own fascinating stories, like the case involving a Harrier jet promised in a Pepsi promotion, Leonard v. PepsiCo.
Right, that Harrier jet case. Those cases are fantastic for bringing these, abstract legal concepts right down to earth. They show us how these principles we're going to discuss actually play out in real life, sometimes in pretty unexpected ways.
Exactly. So our mission today is to give you, the learner, a clear and efficient roadmap to understanding contract law. We're going to extract the key insights from Angela's notes to provide you with a solid overview without, hopefully, overwhelming you with too much legal jargon.
We're essentially charting the life of a contract, right? From its very beginning to its potential end, and exploring everything that can happen along the way.
Perfect. We'll start by looking at what makes a contract validly formed.
Then we'll explore the reasons why a seemingly valid agreement might not actually be enforced by a court.
Then we'll get into understanding the actual terms. What does the contract mean?
And the journey of the contract through performance, what happens if it's breached?
Right. The remedies available when things go wrong.
And even how individuals who weren't originally part of the deal can still get involved. Third parties.
So a full spectrum view of contract law, all distilled down for you. Ready to get started?
Let's do it.
Okay, let's unpack this.
Let's begin by defining what we're even talking about. What is a contract? Angela's notes start with a general definition and immediately point out a really important distinction.
Which is?
The difference between common law principles, which govern many types of contracts, like services, and Article 2 of the Uniform Commercial Code, or UCC, that specifically deals with contracts for the sale of goods. Tangible things.
That distinction is key, isn't it? Because it determines which set of rules applies. Like buying a car goods, so UCC.
Exactly. But hiring someone to, say, landscape your yard, that's a service, so that's probably going to fall under common law.
And Angela's notes highlight that sometimes deals involve both, right? Goods and services.
Yeah, mixed contracts. In those cases, courts usually have to figure out which part is the dominant aspect of the deal. Unless the payment is clearly divided between the goods and the services, the dominant purpose test usually applies.
Okay. And within the UCC, Angela's notes mention the idea of a merchant. That's important too.
Very important. A merchant isn't just, anyone selling something. The UCC has a specific definition. It's someone who regularly deals in the type of good being sold or holds themselves out as having special knowledge about those goods.
Why does that matter?
Well, being a merchant can trigger special rules under the UCC, like the implied warranty of merchantability, which basically says goods sold by a merchant have to be fit for their ordinary purpose. That applies automatically to merchants.
Gotcha. Angela's notes also break down contracts into different categories, like express contracts.
Right. Express contracts are where the terms are clearly stated, either orally or in writing. Pretty straightforward.
And implied, in fact.
Implied, in fact, contracts are formed by the actions of the parties. Like if you go to the doctor, you don't usually sign a contract saying you'll pay, but it's implied by your actions of seeking treatment that you agree to pay for the service.
Okay. And quasi-contracts. Those sound a bit different.
They are different. As Angela's notes explain, quasi-contracts aren't actually true contracts based on agreement. They're more like a legal fiction created by courts.
That legal fiction, why?
To prevent unjust enrichment. Basically, if someone unfairly benefits at another's expense and there wasn't a real contract, a court might impose a quasi-contractual obligation to make things fair.
Interesting. Angela's notes also mention categories based on how acceptance happens and the contract's validity.
Exactly. So based on acceptance, you have bilateral contracts. That's the most common type involving an exchange of promises. I promise to do X if you promise to do Y.
A promise for a promise.
Right. Then you have unilateral contracts where acceptance happens through actually performing a specific act, like I'll pay $100 to whoever finds my lost cat. Acceptance is finding the cat, not promising to look.
Okay. And validity.
Based on validity, a contract can be void, meaning it has no legal effect from the get-go, like a contract to commit a crime. It can be voidable, meaning one party has the option to cancel it, like many contracts made by minors. Or it can be unenforceable. Maybe it's technically valid, but some rule prevents a court from enforcing it, like the statute of frauds, which we'll get to.
Got it. And the cornerstone of actually forming a contract is what Angela's notes call mutual assent, right?
That's the foundation. Mutual assent means the parties have agreed to the same bargain. It requires two key things, a valid offer and a valid acceptance.
So let's start with the offer. What makes something a legally valid offer?
Well, Angela's notes state that an offer needs to be a clear promise, undertaking, or commitment. It has to show a real intent to enter into a contract.
And how do you judge that intent?
objectively. It's not about what the person making the offer was secretly thinking. It's about how a reasonable person receiving the communication would interpret it. You look at the language used, the surrounding circumstances, any prior dealings, how it was communicated. All that matters.
So just saying, I might sell my bike for $200 probably isn't an offer.
Probably not. Too tentative. But I will sell you my bike for $200. That sounds much more like an offer. And Angela's notes mention that things like price quotes or invitations to negotiate are usually not offers either.
What about ads? Like in a newspaper or online? Are those offers?
Generally, no. Angela's notes explain that most advertisements are treated as invitations to deal or invitations to make an offer. Think about it. If a store ad was an offer, they could be bound to sell to everyone who showed up, even if they ran out of stock.
Makes sense. Unless the ad is really specific.
Right. If an ad is very specific, clear, and leaves nothing open for negotiation, like use sofa, $50, first person here gets it, then it might be considered an offer, but that's more the exception.
Okay, so an offer needs that commitment. It also needs to be clear about what is being offered, right? Angela's notes talk about definite and certain terms.
Yes, absolutely. For an offer to be valid, the terms need to be definite enough so that if it's accepted, a court can figure out if someone breached the contract and what the remedy should be.
What kind of terms need to be definite?
Usually, you need to be able to identify who the offer is made to, or the offeree, and the subject matter of the contract. For specific types, like real estate, Angela's notes say you typically need the land identified and the price. For sales of goods under the UCC, the quantity term is usually essential.
But Angela's notes also mention requirements and output contracts. Those don't seem to have a specific quantity up front.
That's true. They're a bit of an exception. In a requirements contract, a buyer agrees to buy all they need of a certain good from one seller. In an output contract, a seller agrees to sell all they produce of a certain good to one buyer.
So how are those definite enough?
Angela's notes explain they're generally considered definite because the quantity, while not a fixed number, is tied to objective factors, the buyer's actual good faith requirements or the seller's actual good faith output. There are limits, though. The quantity can't be unreasonably disproportionate to estimates or past history.
What if an offer is just missing some terms? Like they agree on the goods and quantity, but not the delivery date. Is it invalid?
Not necessarily. Angela's notes point out that if it's clear the parties intended to make a contract and there's a reasonable basis for a court to figure out a remedy, a contract can still be formed even with some missing terms.
Especially under the UCC.
Exactly. Article 2 has these things called gap fillers. If terms like price, delivery time, or place of delivery are missing, the UCC can often supply a reasonable term based on usual practices or the circumstances. Price, for instance, might be filled in as a reasonable price at the time of delivery.
But under common law, it might be trickier.
A bit trickier, yeah. Angela's notes caution that under common law, if really essential terms, especially material ones, are left open for future negotiation, the offer might be deemed too uncertain to be valid. The UCC is generally more flexible, particularly with price.
Okay, so we have a valid offer on the table. How does the other side accept it? How does acceptance work?
Acceptance, as Angela's notes lay it out, is the offeree's clear manifestation of assent to the terms of the offer. Basically saying yes in a way the offer allows.
And how can you say yes?
Generally, an offer can be accepted by making a return promise that forms a bilateral contract, promise for a promise. Or, in some cases, by performing the requested act, that's how you accept a unilateral contract offer. The modern view, as highlighted in Angela's materials, leans towards interpreting offers as allowing acceptance by either promise or the start of performance, unless the offer clearly restricts it.
You mentioned unilateral contracts are less common now.
That's right. Angela's notes suggest they're now mostly limited to situations where the offer explicitly requires acceptance only by performance, or in contexts like public rewards or contests. Think, find my dog again.
So if someone offers to pay me $500 to paint their fence and says, you can only accept by finishing the job, what happens if I start painting? Can they suddenly revoke the offer?
Good question. Once the offeree begins performance in a true unilateral contract situation, Angela's notes indicate the offer's power to revoke becomes limited. They generally have to give the offeree a reasonable time to actually complete the performance.
But just getting ready isn't enough, like buying the paint.
Correct. There's a distinction between starting performance and merely preparing to perform. Angela's notes clarify that revocation is usually still possible during the preparation stage. Although, as we might discuss later with promissory estoppel, if you relied heavily on the offer and spent a lot on prep, you might have some recourse, but not necessarily through enforcing the contract itself.
Makes sense. Now, who decides how an offer can be accepted? Can the offerer lay down the rules?
Absolutely. The offer is often called the master of the offer. They can dictate the specific manner of acceptance. If the offer says accept only by certified mail, then sending a regular email isn't a valid acceptance.
So you have to follow their instructions exactly.
Generally, yes, if they make it a strict requirement. And importantly, Angela's notes remind us, the offeree has to actually know about the offer to accept it. You can't accidentally accept an offer you weren't aware of.
What about silence? If I get an offer in the mail and just ignore it, is that acceptance?
Usually no. Angela's notes state the general rule. Silence does not equal acceptance. You typically need some positive act to show you agree.
Are there exceptions?
Yes, a few narrow ones. If past dealings between the parties have established silence as acceptance, or if the offeree takes the benefit of offered services with a reasonable chance to reject them and knows they were offered with the expectation of payment, then silence might operate as acceptance. But these are exceptions.
And the mailbox rule. I remember hearing about that. When is a mailed acceptance effective?
Right, the mailbox rule. Angela's notes explain this common law principle. Acceptance sent by mail is generally effective when it's dispatched, meaning put into the control of the postal service, properly addressed and stamped.
Not when it's received.
Correct. Effective upon dispatch, provided mail was a reasonable means of acceptance in that situation. This rule typically protects the offeree against the offer being revoked while the acceptance is in transit. However, things like revocations or rejections are usually effective only upon receipt.
Okay, what if I reply to an offer saying, yes, I accept, but I need delivery by Friday? Is that an acceptance?
Under traditional common law, no. That would likely be treated as a rejection of the original offer and a counteroffer. Angela's notes call this the mirror image rule. The acceptance has to exactly mirror the terms of the offer. Any variation creates a counteroffer.
But the UCC is different. You mentioned the battle of the forms.
Exactly. The UCC, especially in deals between merchants, changes things. Angela's notes explain that under UCC Section 2207, an acceptance that states additional or different terms might still form a contract. The fate of those extra terms depends on specific rules, like whether both parties are merchants, whether the terms materially alter the contract, etc. It's definitely more complex than the common law mirror image rule.
Okay, so we've covered offer and acceptance, the two parts of mutual assent. What's the next big piece needed for a binding contract?
That would be consideration, the third essential element.
And what is consideration exactly?
Angela's notes define it as a bargain for exchange of legal value. Essentially, each party has to give something up, or promise to give something up, in return for what they're getting from the other party. It's the price paid for the promise.
Does it have to be money?
Not at all. Legal value can be an act, a forbearance, refraining from doing something you have a legal right to do, or a return promise. The key, as Angela's notes emphasize, is that the promisee must suffer a legal detriment doing something they're not legally obligated to do, or not doing something they have legal right to do. And the promiser must receive a legal benefit, though that benefit doesn't have to be economic.
And courts don't usually care if it's a fair trade. The peppercorn theory.
Right. Courts generally don't inquire into the adequacy of consideration. As long as there's some legal value, even if it seems tiny or disproportionate, it's usually sufficient. However, Angela's notes do add that gross inadequacy might sometimes be evidence of other problems like fraud, duress, or lack of capacity.
What about promises based on things that already happened? Angela's notes mention past or moral consideration. Does that count?
Generally, no. Angela's notes explain that past consideration isn't valid consideration because it wasn't bargained for in exchange for the current promise. The act was already done before the promise was made.
Are there exceptions?
A few limited ones. Sometimes a promise to pay a debt barred by a technical defense, like the statute of limitations, might be enforceable without new consideration. And Angela's notes mention the material benefit rule in some states, where a promise made in recognition of a significant past benefit received might be enforceable to prevent injustice. But the general rule is past consideration is no consideration.
And what if I promise to do something I'm already legally required to do?
Right.
Like if a builder demands more money halfway through a job just to finish what they already agreed to do, Angela's notes mention the pre-existing legal duty rule.
That's a classic example. The general rule is that promising to perform or performing a pre-existing legal duty does not constitute valid consideration for a new promise from the other party. The builder is already obligated to finish the job for the original price.
But there are exceptions here too.
Yes, quite a few, outlined in Angela's notes. If there's new or different consideration offered, if the duty was voidable, if the duty is owed to a third party, if there's an honest dispute about the original duty, or if there are unforeseen difficulties that make performance much harder than anticipated, though this one is tricky. And importantly, Angela's notes highlight that under the UCC, modifications to contracts for the sale of goods don't need new consideration, they just need to be made in good faith.
One more on consideration. What about a surety? Like someone promising to guarantee someone else's loan, but they make that promise after the loan has already been given.
Angela's notes explain that often that promise lacks consideration. The lender didn't give the loan in reliance on the surety's promise, they'd already given it. So the surety's later promise is often just a gratuitous promise and not enforceable unless some other factor applies.
Okay, so we need offer, acceptance, and consideration for contract formation. But even if we have all three, Angela's notes say a contract might still not be enforceable because of certain defenses. Let's get into those.
Right. Even with those building blocks in place, certain things can make a contract invalid or give one party a way out. Angela's notes start with lack of capacity.
Who lacks capacity?
Primarily, Angela's notes mention infants or minors, usually under 18, and individuals with mental incapacity severe enough that they can't understand the nature and consequences of the contract they're entering into.
And what happens if they make a contract?
Contracts made by minors or those with mental incapacity are generally voidable at their option. They can choose to disaffirm or cancel the contract. The adult or competent party on the other side usually doesn't get that choice.
Are there any exceptions? Do they have to pay for anything?
Yes, Angela's notes point out they are usually liable for the reasonable value of necessaries, things like food, shelter, clothing, medical care. And importantly, once a minor reaches the age of majority, 18, they can choose to affirm or ratify the contract, making it fully binding on them. Okay, Angela's notes also talk about duress and undue influence. How are those different?
Both involve improper pressure, but duress is generally more about coercion or threats. Angela's notes distinguish physical compulsion, like literally forcing someone's hand to sign, which makes the contract void. More common is duress by improper threats, threats of physical harm, economic harm, wrongful legal action that leave the victim with no reasonable alternative. This makes the contract voidable by the victim.
And undue influence.
Undue influence, as Angela's notes describe it, is more about unfair persuasion, often in a relationship where one party has a lot of trust or dominance over the other, like a caregiver and an elderly person, or a lawyer and client. It's about overcoming the weaker party's free will through unfair pressure, making the contract voidable.
Got it. Another big defense is illegality. Pretty self-explanatory.
Mostly, yes. Angela's notes explain that if the subject matter of the contract is illegal, or the consideration is illegal, or the contract's purpose is illegal, courts generally won't enforce it. They usually leave the parties where they found them.
Are there exceptions where a court might help one party?
Sometimes. Angela's notes mention situations where one party was justifiably unaware of the illegality, or where the parties aren't equally at fault. In pari delicto is the term Angela's notes use. The less culpable party might get some relief.
What if the parties just fundamentally misunderstood each other about a key term?
That's the defense of misunderstanding in Angela's notes. If both parties attached materially different meanings to an essential term, and neither party knew or had reason to know about the other's different meaning, then there was no real mutual assent, no meeting of the minds, so no contract was actually formed.
Then there's mistake. Sounds similar but different.
Yeah, mistake is about believing something that's just not true about the facts at the time the contract was made. Angela's notes distinguish between mutual mistake and unilateral mistake. Mutual mistake.
That's when both parties share the same mistaken belief about a basic assumption on which the contract was made, and that mistake has a material effect on the agreed exchange. This can make the contract voidable by the party who's adversely affected. Think buying land believed to have timber, but it already burned down unknown to both.
And unilateral mistake, just one party is wrong.
Right. Usually one party's mistake doesn't let them avoid the contract. However, Angela's notes point out exceptions. If the other party knew or should have known about the mistake, or if the mistake was just a clear mathematical or clerical error, the mistaken party might be able to get out of it.
Angela's notes also mention mistake in the writing.
Yes, sometimes the written contract doesn't accurately reflect the actual agreement the parties reached due to a mistake. In that case, a court might order reformation, basically, rewriting the contract to match the true agreement. Negligence in making the mistake doesn't necessarily prevent reformation.
Okay, next offense. Misrepresentation.
Mm.
Lying, basically.
Or stating something untrue, yeah. Angela's notes define misrepresentation as an assertion not in accord with the facts. If it's fraudulent, made knowingly, recklessly, or without basis, or even just material, likely to induce a reasonable person to agree, and the innocent party justifiably relied on it, the contract is voidable by them.
Does it have to be intentional?
No, even negligent misrepresentations, made carelessly, can make a contract voidable if they are material and relied upon. However, Angela's notes clarify that simple opinions or predictions usually don't count as misrepresentations of fact.
Let's talk about unconscionability. When is a contract just too unfair to enforce?
Unconscionability is a defense courts can use to police really one-sided or oppressive contracts. Angela's notes explain it generally requires finding both procedural and substantive unconscionability at the time the contract is made.
Procedural and substantive.
Procedural unconscionability is about unfairness in the bargaining process. Think hidden terms in fine print, vastly unequal bargaining power, lack of real choice. Substantive unconscionability is about the terms themselves being overly harsh or unfairly one-sided.
What can a court do if it finds unconscionability?
They have options. Angela's notes say they can refuse to enforce the whole contract, strike out the unconscionable clause and enforce the rest, or limit the application of the clause to avoid an unfair result. Clauses limiting liability, especially for personal injury from consumer goods, get special scrutiny under the UCC, as Angela's notes point out. Okay, the last big defense Angela's notes cover is the statute of frauds. This is about needing contracts in writing.
Exactly. The statute of frauds requires certain specific types of contracts to be evidenced by a signed writing to be enforceable in court. It's designed to prevent fraudulent claims based on alleged oral agreements in important transactions. Which types of contracts need to be in writing?
Angela's notes list the common categories, often remembered by the mnemonic MyLegs. Contracts made in consideration of marriage, contracts that cannot possibly be performed within 1 year from their making, contracts involving an interest in land, contracts by executors to pay estate debts from their own funds, contracts for the sale of goods priced at $500 or more under the UCC, and suretyship contracts, promises to answer for the debt of another.
Let's focus on the UCC one sale of goods for $500 or more. What does the writing need to include?
For the UCC statute of frauds, Angela's notes say the writing needs to do 3 main things. First, indicate that a contract for sale has been made between the parties. Second, it must be signed by the party against whom enforcement is sought, or their agent, and signed, is defined broadly under the UCC. Even a letterhead might count. Third, it must specify the quantity of goods.
And the contract is only enforceable up to that quantity.
Correct. That's a key point in Angela's notes for the UCC rule.
Are there ways around the statute of frauds? Exceptions where an oral contract might still be enforced.
Yes, Angela's notes detail several important exceptions. For land contracts, part performance by the buyer, like paying part of the price, taking possession, and making improvements, might make an oral contract enforceable. For goods under the UCC, exceptions include contracts for specially manufactured goods not suitable for others, situations where a party admits in court that a contract was made, and where goods have been accepted or paid for, the contract is enforceable only for the quantity accepted or paid for.
And the 1-year rule.
Oh, right. If a contract could possibly be fully performed within 1 year, even if it's unlikely, it's outside the statute of frauds and doesn't need a writing based on that rule. Angela's notes also mention a special UCC rule for merchants. If one merchant sends a written confirmation to another and the receiver doesn't object within 10 days, it can satisfy the statute against the receiving merchant even if they didn't sign it.
So what happens if a contract is supposed to be in writing under the statute of frauds, but it isn't, and no exception applies?
Then, according to Angela's notes, the contract is typically unenforceable at the option of the party being sued. They can raise the statute of frauds as a defense. If they don't raise it, the defense is usually considered waived.
Okay, whew, that's a lot on defenses.
No.
So, assuming we have a valid, enforceable contract, how do we figure out exactly what it means? The content and meaning part from Angela's notes.
Right. Once we know we have a contract, we need to interpret it. Angela's notes say the starting point is always the express terms, the words the parties actually used, written or oral. Courts try to give effect to the party's intent. Using an objective standard, what would a reasonable person think the terms mean?
But what if the written contract seems complete, but one party says there were other agreements made before or at the same time? That sounds like the parole evidence rule Angela's notes mention.
Exactly. The parole evidence rule is crucial here. It limits the extent to which parties to a written contract, intended as the final expression of their agreement, can introduce evidence of prior or contemporaneous agreements, oral or written, to contradict, vary, or add to the terms of the written contract.
So it keeps outside stuff out.
Sort of. It depends on whether the written contract is considered integrated. Angela's notes distinguish between a complete integration intended as the final and exclusive statement of all terms and a partial integration final as to the terms it includes, but not necessarily the whole deal.
How does that affect the outside evidence?
If it's a complete integration, Angela's notes say no extrinsic evidence of prior or contemporaneous agreements can come in to contradict or supplement the writing. If it's only partially integrated, evidence of consistent additional terms that don't contradict the writing might be allowed to supplement it.
Are there times when parole evidence is always allowed?
Yes. Angela's notes emphasize it's generally always admissible to clarify ambiguities in the writing, to prove defenses to formation, like fraud, duress, mistake, or to show that the contract was modified after the writing was made. Subsequent modifications aren't barred by the rule.
Angela's notes also mention using course of performance, course of dealing, and usage of trade to interpret contracts. What are those?
These are tools to understand the context and meaning, even for integrated agreements. Course of performance is how the parties have acted under this specific contract. Course of dealing is how they've acted in past contracts with each other. Usage of trade is standard practice in the relevant industry or locality.
And how do they fit in?
Angela's notes explain they can be used to explain or supplement contract terms as long as they don't contradict the express terms. There's a hierarchy. Express terms control over course of performance, which controls over course of dealing, which controls over usage of trade.
What if a contract is just missing terms like price or delivery under the UCC? We mentioned gap fillers before.
Right. If the parties intended to contract but left terms open, UCC Article 2 provides those gap fillers Angela's notes cover. Reasonable price at time of delivery, delivery at seller's place of business, reasonable time for shipment, payment due on receipt of goods. Things like that can be filled in by the court if needed, assuming the quantity term is present.
Angela's notes also stress an implied duty of good faith and fair dealing in every contract.
Yes, a fundamental principle. Every contract, common law or UCC, imposes this duty. It means parties have to act honestly and fairly in performing and enforcing the contract. You can't deliberately undermine the other party's ability to receive the benefits of the contract. It also helps interpret ambiguous terms.
And sometimes there are other implied duties, like best efforts.
Yes, Angela's notes mention that in exclusive dealing contracts under the UCC, where a seller agrees to sell only to one buyer or vice versa, there's an implied duty to use best efforts the seller to supply, the buyer to promote.
Okay, let's talk about conditions. Angela's notes say these are events that affect a party's duty to perform.
Exactly. A condition is an event, not certain to occur, which must occur or not occur before performance under a contract becomes due, or which discharges a duty that has already arisen. They can be expressed stated clearly in the contract using words like if, provided that, unconditioned that.
Or implied.
Or implied, meaning understood from the nature of the contract. Constructive conditions of exchange are a big type of implied condition. The idea that my duty to perform is conditioned on your duty to perform, especially when performances can happen simultaneously.
Angela's notes also distinguish conditions precedent and subsequent.
Right. A condition precedent must occur before a duty to perform arises. A condition subsequent, if it occurs after performance has begun or become due, will extinguish or discharge that duty. There's also conditions of satisfaction. My duty to pay might be conditioned on my being satisfied with your work.
How is satisfaction judged?
It depends. If it involves personal taste or judgment, like a portrait painting, it's usually a subjective, standard, honest, good faith satisfaction. If it's about mechanical fitness or utility, it's usually an objective, reasonable person standard.
Can a condition be excused, like you don't have to meet it anymore?
Yes. Angela's notes list ways. If the party who benefits from the condition wrongfully prevents it from occurring, it's excused. A party can also waive a condition, intentionally give up the right to it, and if the condition becomes impossible or impracticable to meet, it might be excused. All right, so we understand the contract. Now, what about actually doing what it says? Performance, breach, and discharge, according to Angela's notes. Let's start with performance under the UCC's perfect tender rule.
The perfect tender rule. Angela's notes explain that under UCC Article 2, the seller's delivery of goods must generally conform exactly to the contract terms, quantity, quality, manner of delivery, everything.
Exactly. That sounds strict.
It is, but there are important exceptions noted in Angela's materials. The biggest is the seller's right to cure. If the seller delivers non-conforming goods before the contract deadline, they usually have the right to make a conforming delivery within the original time. Sometimes they even get a chance to cure after the deadline if they had reasonable grounds to think the non-conforming tender would be acceptable.
And the buyer has obligations, too.
Absolutely. Buyers need to inspect the goods within a reasonable time and either accept them or reject them properly if they don't conform. Failure to reject properly can be deemed acceptance.
Okay, so what happens if someone doesn't perform? What's a breach?
Simply put, Angela's notes define a breach as any failure to perform a contractual duty when it's due. But not all breaches are equal. The key distinction is between a material breach and a minor breach.
Material breach.
That's a serious one. A substantial failure to perform that undermines the core purpose of the contract. Angela's notes explain that a material breach by one party generally excuses the non-breaching party from their own performance obligations and gives them the right to sue for total damages.
And a minor breach.
A less significant failure. The non-breaching party still gets the substantial benefit of the bargain. They can sue for damages caused by the minor breach, but they still have to perform their side of the deal. Angela's notes also mention substantial performance if a party performs most of their obligations in good faith. With only minor deviations, they haven't materially breached and can recover the contract price, minus damages for the defects, unless the breach was willful.
What about divisible contracts?
If a contract can be broken down into pairs of agreed equivalents, like payments for distinct stages of construction, Angela's notes say a party who substantially performs one part can recover for that part, even if they breach another part.
Angela's notes also discuss anticipatory repudiation. That's breaching before performance is even due.
Exactly. It's when one party makes an unequivocal statement or takes clear action indicating they will not perform their future obligations. Angela's notes say this immediately gives the non-repudiating party options.
Like what?
They can treat it as an immediate breach and sue for damages right away, or they can suspend their own performance and wait for the performance date to see if the other party retracts the repudiation.
Can a repudiation be taken back?
Yes. Angela's notes mention that a repudiating party can retract their repudiation unless the other party has already relied on it, like hiring someone else, accepted the repudiation, or sued.
What if it's not a clear refusal, but you just have strong doubts the other side will perform? Angela's notes call this prospective inability or unwillingness.
In that situation, if you have reasonable grounds for insecurity, Angela's notes explain you can demand adequate assurances of due performance from the other party, usually in writing under the UCC. If they fail to provide those assurances within a reasonable time, not exceeding 30 days under UCC, you can treat that failure as a repudiation.
Okay, so contracts can be breached. How do they end? How are contractual duties discharged, as Angela's notes put it?
Well, the best way is full performance by both sides. But Angela's notes list many other ways. Tender of performance, offering to perform when ready, willing, and able, can discharge duties if rejected. Occurrence of a condition subsequent. Supervening illegality if the contract becomes illegal after it's formed.
And then there's impossibility, impracticability, and frustration of purpose. Those sound related.
They are. Impossibility, as Angela's notes explain, is when performance becomes objectively impossible for anyone. Death of necessary persons, destruction of unique subject matter. Impracticability, often used under UCC, is when performance becomes extremely and unreasonably difficult or expensive due to an unforeseen event, the non-occurrence of which was a basic assumption of the contract. Mere increased cost isn't enough. Frustration of purpose is when an unforeseen event completely undermines the reason for entering the contract, even if performance is still technically possible. Think renting a room for a coronation parade that gets canceled.
Can the parties themselves agree to end the contract?
Definitely. Mutual rescission is when both parties agree to cancel the contract. Angela's notes point out this requires consideration, usually. Each party gives up their right to the other's performance, assuming the contract is still executory, unperformed, on both sides.
What about accord and satisfaction?
That's a two-step process noted in Angela's materials. An accord is a new agreement to accept a different performance than what was originally owed, often to settle a dispute. Satisfaction is the actual performance of that new agreement. Once satisfaction occurs, the original obligation is discharged.
And novation.
Novation involves substituting a new party for an original party. Angela's notes describe it as a freeway agreement where the original party is completely released and the new party takes over their obligations. All parties must agree.
And a lapse.
A contract can simply lapse if time is of the essence,
Yeah.
the deadline passes, or if a reasonable time passes without performance when duties are concurrent.
Okay, so a breach happened, the contract wasn't discharged properly. What can the non-breaching party do? Let's talk remedies, based on Angela's notes.
Right. Remedies are about fixing the harm caused by the breach. Angela's notes explain the main goal is usually to compensate the injured party, not punish the breaching party. So punitive damages are generally not available in contract cases unless the breach is also a tort like fraud.
What's the main type of compensation?
Expectation damages. Angela's notes state this is the standard measure. The goal is to put the non-breaching party in the economic position they would have been in if the contract had been fully performed.
How are those calculated?
It usually includes the direct loss in value from the breach, plus any incidental damages, costs reasonably incurred trying to deal with the breach, like finding a replacement, and consequential damages, foreseeable losses resulting from the breach that were known or should have been known by the breaching party at the time of contracting, like lost profits.
Are there limits on damages?
Yes. Two big ones highlighted in Angela's notes. Damages must be proven with reasonable certainty, and the non-breaching party has a duty to mitigate. They must take reasonable steps to minimize their losses after the breach. You can't just sit back and let damages pile up if you could have reasonably prevented some of them.
What are reliance damages?
Reliance damages, noted in Angela's materials, aim to put the non-breaching party back in the position they were in before the contract was made. They compensate for expenditures made in reliance on the promise. This is sometimes used when expectation damages are too speculative.
And restitution?
Restitution aims to prevent unjust enrichment. It allows the non-breaching party, or sometimes even a breaching party, to recover the value of any benefit conferred on the other party. It's about giving back the value received. Quasi-contractual remedies are based on this principle, too.
Angela's notes also mention liquidated damages clauses. What are those?
Those are clauses parties put in the contract specifying the amount of damages to be paid if a specific breach occurs. Angela's notes say they're enforceable if the amount was a reasonable forecast of likely damages at the time of contracting, and actual damages would be difficult to calculate. But if the amount is unreasonably large and looks like a penalty, courts won't enforce it.
What if money just isn't enough? Are there other kinds of remedies?
Yes, equitable remedies. Angela's notes discuss specific performance, where the court orders the breaching party to actually perform the contract. This is usually only available when the subject matter is unique, like land or a rare piece of art where money damages wouldn't be adequate. Courts generally won't order specific performance of personal service contracts, though.
Any others?
Reformation, which we mentioned earlier, rewriting the contract to reflect the party's true agreement if there was a mistake in the writing, and rescission, canceling the contract and restoring parties to their pre-contract positions.
Okay, final area from Angela's notes. Third-party rights. How can people who weren't the original contracting parties get involved?
Great question. Angela's notes cover three main ways: third-party beneficiaries, assignment of rights, and delegation of duties.
Let's start with third-party beneficiaries.
This happens when two parties make a contract intending to benefit a third person. Angela's notes explain that if the parties intended to give this third party enforceable rights, they are an intended beneficiary. They can be either a done beneficiary, if the promisee intended the benefit as a gift, or a creditor beneficiary, if the promisee intended the performance to satisfy a debt owed to the third party.
And only intended beneficiaries can sue.
Correct. Incidental beneficiaries, those who might benefit but weren't the intended recipients, generally have no rights under the contract. Intended beneficiaries, however, can sue the promisor directly to enforce the promise. Angela's notes also clarify the rights between the original parties and the beneficiary.
Okay, what about assignment?
Assignment, according to Angela's notes, is the transfer of a contractual right from one original party, the assigner, to a third party, the assignee. The assigner gives up the right, and the assignee steps into their shoes and can receive the performance from the other original party, the obliger.
Can all rights be assigned?
Most can, unless the assignment would substantially change the obliger's duty or risk, or if the contract or a statute prohibits it. Angela's notes also mention that gratuitous assignments, made without consideration, are generally revocable unless the assignee has already received payment or relied on it detrimentally.
And the assignee can sue the obligor.
Yes, directly. But the assignee is subject to any defenses the obligor could have raised against the original assigner. Angela's notes also cover rules about notice to the obligor and what happens if the same right gets assigned multiple times.
And finally, delegation. How is that different from assignment?
Delegation is about transferring a contractual duty to perform, as explained in Angela's notes. The original party, the delegator, gets a third party, the delegate, to perform their obligation.
Does the delegator get off the hook?
Usually not. Angela's notes emphasize that the delegator generally remains liable for performance, even after delegating the duty, unless there's a novation where everyone agrees to release the delegator.
Are all duties delegable?
No. Duties involving personal skill or judgment, or where there's a special trust relationship, are typically non-delegable. And contracts can also prohibit delegation. If a duty is properly delegated, the party owed performance, the obligee, generally must accept performance from the delegate, but they can still look to the delegator if the delegate messes up. Wow, okay, we have definitely covered a significant amount of ground there. That was quite the deep dive into the introduction of contract law, all thanks to Angela's comprehensive notes.
Yeah, we really went from the cradle to, well, potentially the grave of a contract, didn't we? Formation, things that stop enforcement, understanding the terms, performance, breach, remedies, even third parties.
You've now got, hopefully, a really solid foundational understanding of these key concepts offer acceptance, that crucial element of consideration.
Right, and the various defenses like capacity or the statute of frauds, the importance of clear terms, what actually counts as a breach, and what your options are when things don't go according to plan.
Plus, you're now aware of those nuances with third-party involvement, beneficiaries, assignments, delegations. It's a lot, but it connects.
Think back to those cases we mentioned at the start. Paul's graph. Okay, a torts case, but it highlights duty and foreseeability, which echo in contract remedies, right? And Leonard v. PepsiCo with the Harrier jet.
Yes. A classic example of why an offer needs to be, clear and definite and objective. Hopefully understanding these basic principles gives you a new lens to view those kinds of scenarios.
Absolutely. This deep dive was really designed to give you, the learner, that clear, concise overview, hitting the most important nuggets from Angela's notes. We tried to balance the summaries with enough specifics to make it stick without, drowning you.
Yeah, hopefully it felt valuable, maybe sparked some aha moments, and wasn't just overwhelming.
So what does this all mean for you, the learner? It means you're now equipped with a fundamental grasp of a legal system that shapes countless interactions every single day.
Seriously, whether you're clicking I agree online, signing an apartment lease, starting a business, or just curious about how deals work legally, these principles are everywhere.
And for your continued thinking on this, consider how those principles we touched on, like good faith and fair dealing, or even offer and acceptance, how are they adapting or maybe struggling to adapt to our super fast-paced digital world? Online contracts, smart contracts, it's a really fascinating area where old rules meet new tech.
That's a great point to ponder. Thank you so much for taking this deep dive into the fundamentals of contract law with us today.
We really hope it's been a valuable shortcut to becoming well-informed on this vital topic.
Absolutely. Until our next exploration, keep that curiosity burning.
Hey everyone, it's Angela, and I'm back. So I hope you enjoyed that overview of what we'll be getting into for contracts. So we're going to start off the next podcast with contract formation. All that stuff, offer, agreement, consideration, mutual assent, etc. If you need to reach me, you can reach me at podcast@studyforthebarinyourcar.com. Or if you need any legal work. So if you are an attorney or you know an attorney who needs some remote ad hoc work, too much work on your hands, you can call on me. I'm a law clerk. You can reach me at hello@legalwriterandlawclerk.com. That's it, and we'll see you on the next episode.